Thank you. I'm very honored this morning to introduce Angela Saranzana. She is an attorney and specializes in HR and employment information, and she's anxious to share some information with you. She's going to focus on small businesses and some of the pitfalls and how to avoid them.
Yes.
Angela, I'll let you take it away.
Absolutely. I'm so excited to be here. I actually wish I was taking notes on everything that you all do, because I'm like, oh, chiropractor, gotcha. And I'm just like, oh, interior design, gotcha. I've been doing employment law for my entire career. It'll be 22 years this next year. And I've only ever practiced in labor and employment law. So I was a union lawyer for about 10 years, and then I switched over, and now I focus on employer side consultation and defense. We had a partner meeting yesterday, and the range of businesses that we represent is pretty vast. We have a couple of people with 1 or 2 employees. We have people with 2,500 employees. So from construction to your mom and pop shops, I've seen it all over the course of the last 2 decades. If you guys have any questions that I don't cover today, please feel free to reach out. And I try to be pretty good about if you're just asking me a question, I'm never going to charge you. If it's a 5-minute conversation, you can give me a call. I want you guys to do well. And Jesse can attest, my focus is on making sure that businesses are strong, that they stay out of trouble, and that is I want you guys to do well. So please interrupt. I'm going to go over some major points, but if you guys have questions, I'm happy to get into the conversation. California is maybe the hardest state to be an employer. There are a lot of rules that are not common sense, but are rules. You have to follow them, and they may not be intuitive. If you don't follow them, there are pretty big consequences. So I would prefer, this is why I don't really charge for little questions, because these can be big mistakes. And I would prefer that you stay out of those mistakes than have to dealing with them afterwards. That being said, happy to help you deal with them afterwards as well. The 3 C's that I like to talk about are compliance, clarity, and consistency. Those are the 3 things that if you follow those through with all of your business practices, you're probably going to be in pretty good shape. One is compliance, making sure that you have a handbook that is up to date and is has the right information, right? And you don't need a lawyer for that. You can Google employee handbooks. They'll come up, employee handbooks 2026. Make sure that you have the correct year, and those are available, widely available. Make sure that they're consistent with your industry, because different industries have different rules. But employee handbook 2026, you don't need a lawyer for that. Clarity. Make sure that you disseminate those handbooks to everyone, to your entire workforce. That everybody who is hired gets a copy of those handbooks, and that they're available for anyone who asks for them, and for your managers, and that they know. Consistency. If you have these rules, these handbooks, make sure that you are implementing all of those rules with all of your employees the same way. I know we all have favorites. I know that some employees are better than others. We all know this, right? But make sure that if you have rules that have concrete criteria, that you are applying the criteria the same for each and every employee, right? Because if you don't, you run into questions of, was this discriminatory? Was this applied differently for a reason that is not so above board, right? Did they do it because I was a woman? Did they do it because I was Asian? Did they do it because I'm gay? All of those things, right? If you apply the rules consistently, you don't have those questions, right? You're like, these are my rules. This is how we apply it. This is why the thing turned out the way that it did. So, compliance, clarity, consistency. Now, let's get into specifics. Number one, does anybody know what minimum wage is here in California right now in 2026?
1720?
I love that the answer was actually above what the state minimum wage is. In 2026, the state minimum wage is $16.90. Different municipalities have different minimum wages. In Los Angeles, I believe it's $17.20, but the statewide minimum is $16.90 before January 1st and before July 1st. All of you should be Googling minimum wage in South Pass to make sure, because those are the dates that those minimums go up. Does anybody know what the minimum for salaried employees is currently?
Double minimum wage?
Sorry?
Double minimum wage?
It is absolutely tied to minimum wage. I don't do math. So I know what the annual amount is. Does anybody know what the annual amount is? It's currently as of January 1st, it's $70,304. If you are paying anyone on a salary basis, you need to be paying them above 7304 is what you need to do.
Does that require that they work 40 hours a week?
No. So, here's a major thing that people often come to me with, and it always surprises me, but it shouldn't anymore. You can always pay somebody on an hourly basis. Always. Doesn't matter what they do, doesn't matter what their title is. However, to pay someone on a salary basis, there are certain things that you need to meet. They need to fall into one of three categories. They need to either be a professional, meaning they have some sort of license, like an attorney or a doctor or an accountant, something, a professional license that the state gives them sort of a certification or a license for. Higher education, usually, 2 to 4 years. They need to be an executive on the executive team, meaning that they deal with sort of the running of a business, right? Like your managers, your HR, your accounting, not the day-to-day, or administrative, meaning that they assist with that, assist an executive. You can't pay a clerk on a salaried basis. Even if you paid them $120,000, you can't pay a clerk. You can't pay a warehouse person on a salary basis. You can't pay a receptionist on a salaried basis. Those people must be paid on an hourly basis. On a salaried basis, they get paid no matter how much like extra work they do or how little work they do. The point of a salaried employee is that they get the same salary every single week, regardless of how much they work, right? And this is why you can only pay people on a salaried basis if they fall into these very specific categories, right? So you can work they can work 90 hours a week. They can also work 5 hours a week. You can always move somebody from salaried to hourly. You should call a lawyer if you're moving somebody from hourly to salary, okay? And then there are very specific things that you need to do. What a wonderful question, because that gets me into what needs to happen with an hourly employee. Because people are like, oh, well, then I'll always pay somebody on an hourly basis, right? There are things that you need to do if you're paying somebody on an hourly basis, right? There are things that seem like they're common sense, but they're not always. If you pay somebody on an hourly basis, obviously the thing that I've touched on is you need to pay them at the minimum wage. You need to pay them overtime, which means that if they work over 8 hours in a day or 40 hours in a week, they need to be paid at time and a half. If they work, over 12 hours in a day, you need to pay them double time. Or, if they're working every single day, on the 7th day, there are all sorts of rules that go into that. If you're working people that on that kind of schedule, you probably should have a lawyer, because there are a lot of rules that go into that. You need to be giving, for an hourly employee, they need to get meal and rest breaks. Rest breaks are, if somebody is working 3.5 hours or more, they need to get a 10-minute paid break. If they're working more than 6 hours, they need to get a half-hour unpaid break. They need to be, at the very least, they need to be clocking out for their meal breaks, right? Would I love you all to be clocking when they're taking their rest breaks? Yes, I would. Is it necessary? No, but it is best practices. To even have them mark, on a piece of paper, that they're taking their rest break at 10:42 and coming back at 10:52. Not necessary, because it's paid. Would I love you to have record of it? Absolutely. When you are in litigation, these kinds of records really help. But at the very least, they absolutely need to be clocking in when they get to work, when they leave for their meal break, when they come back from their meal break, and when they leave at the end of the day. Okay?
On the overtime, you also have to figure out it's not taxed anymore, right?
I'm sorry?
Overtime isn't taxed anymore.
It absolutely is taxed.
It is taxed?
Yes.
QuickBooks said, I thought that was part of the big, beautiful bill.
You should absolutely treat overtime the same way that you treat regular pay.
I didn't mean, so the employee still, okay. All right,
Well, we can talk later, but it is all treated as wages the same way from a tax perspective. There may be things that you can do under the big beautiful bill with your accountant later, but for purposes of payroll, it all gets treated the same. I will say that this all.
What if you have a staff member that doesn't want to take lunch?
Yep, you discipline them.
How?
You.
I do write them up.
Yes.
Good one.
You got it. This comes up all the time. You have to move on it. You say, okay, well, you get 3 write-ups on this. After that, you're fired. I'm sorry. It is so much liability for people. The number of lawsuits that I have that I'm currently defending, I have 3 right now on just meal and rest breaks. And this, like, you can say, for example, if they choose to not take their lunch break, you can have them write it out every time. You can have them put a note in their file that says, I voluntarily chose not to take my lunch break on this day. And then you're covered, right? But if they don't want to do that, you gotta take action because it's so much liability to you. By the way, everybody, if somebody files a wage and hour lawsuit against you, if they win on anything, they get all of their attorney's fees associated with the thing that they won on. So say you hire somebody for a month and they don't take their lunch break 2 times and you don't clock it and you don't discipline them, and then they take you to court. The penalty is an hour, right? An hour of premium pay. So say they make minimum wage or above, they make $18 an hour. They didn't take their lunch break for 2 days. So what is that, $36 is the penalty that you actually owe them, but the lawsuit itself took 5 days. You now owe their lawyer the time it took for them to prepare to win for those 2 hours, which could be anywhere from $50,000 to $100,000. The judge will award that.
So you would pay for your own attorney fees?
Yep.
You would pay for your employees' attorney fees?
Yes.
So what do they have to lose?
This is why I have a job. Unfortunately, it's terrible, but this is why I'm here. This is why it's very important to have a labor and employment lawyer to help you avoid these things. California this is why I said, California is one of the hardest states to be an employer. If you get into a lawsuit, it's honestly, and I will tell you that I was a union side employer for a long time. I'm all about employee rights, I'm all about union rights, but it is basically sanctioned blackmail. Once they've filed the lawsuit, a lot of times the conversation that I have with my clients is, you're going to pay me $70,000 at least to defend this lawsuit. If they want to settle for less than that, you probably want to settle. Everybody, when you leave here, if you have more than 20 employees and you don't have employment practices liability insurance, maybe get on the phone with your carrier, your general liability carrier, and see what that looks like. See how much that is. EPLI.
This comes up with a question. I wasn't accepted in the jury for this particular case.
Yes.
But I think it's because of my background. But anyways, there was an independent contractor that was doing an investigation for the water and power. And he was suing because he didn't have lunch breaks. As an independent contractor, you know, you're investigating, you're looking, and oh, got to take lunch now, and you miss the guy. So I think, what is the application for independent contractors suing for employee rights?
Yes, that's actually a huge question that comes up a lot. Prior to 2018, California was the Wild West, as most places were, for independent contractor versus employee, right? For the most part, if you agreed to be an independent contractor, you could be an independent contractor and they could pay you whatever. I've had this conversation with Jesse, actually. But in 2018, I believe, there was a case called Dynamex that went before the California Supreme Court, which changed the entire game. Dynamex recontextualized how California treats independent contractors versus employees. It adopted what's called the ABC test. Instead of, if you want to be an independent contractor, you can be an independent contractor, it basically said, if you do work for an entity, the default is that you are an employee and should get all of the protections that go with being an employee, unless you meet all of the standards of this ABC test. And then in 2019, the California legislature codified it, which went into effect on January 1st, 2020, and nobody, unfortunately, other things happened in 2020. And so while everybody should have been aware of this shift in the dynamic, it got overshadowed by COVID. And this is somebody had sent a question like, what is the biggest mistake that people make? The thing that is, it's now starting to taper off, but the number one thing that for the last 5 years has come across my desk is people misclassifying misclassifying people as independent contractors where they should be employees. The ABC test is this. One is, A is, you can't control the means of employment, meaning if you set a schedule for them, if you tell them they have to do work at a specific place, or you have rules when they need to like turn in like reports or show up to meetings. If you have those rules, you're already not hitting prong A. Prong C is that it's an area of business that is like generally known to be an independent contractor business, right? So for example, there aren't a lot of independent contractor receptionists, right? So if you hire a receptionist, that's not really a business that like falls under the category of like independent contractor. The real kicker though is the B prong, and it is that the person provides a service that is not in the regular course of business for your business. So for example, we have a law firm. If I hired a paralegal as an independent contractor, that is not going to fly under that B prong because I have a paralegal that I have as an employee. If I have a paralegal that is a W-2 and a paralegal that is an independent contractor, if EDD does an audit or workers' comp does an audit, that's not going to fly.
So, not to go down the deep rabbit hole, but independent contractor / consultant are the same, right?
Yep.
Okay, and then number two is that while this person is doing work that could be classified under the umbrella that this individual does work that no one presently in the office can do.
That is probably going to be okay. That being said, if you have somebody that you think satisfies the ABC test, you want to have a contract, a written contract that specifically lays out that this person is an independent contractor and that they are agreeing to be an independent contractor. It is if there's a gray area even, the presence of a contract is going to help you so much. In your case, right, if there was a gray area and the person agreed in writing to be an independent contractor, doesn't matter when they took their lunch break, if they negotiated their rate.
Yeah, my thought on that is, okay, you bid on a job. And so you bid, I'll do this service for this amount of money. It's a contract. I think that's what it covers, the idea that, yeah, you're an independent, you're in your own business, bidding on a job, you get the job, you can't charge a person as an employee.
Prior to 2028, that absolutely would have been the case. California, I'm sorry? Yeah, California Supreme Court and the California legislature has decided that they're going to take that decision out of the hands of both employers and employees for certain things, right? So for example, I came across a situation recently where a client wanted to hire a remote receptionist. The business is here in Los Angeles County. The receptionist works in NorCal. And they said, okay, well, can we hire them as a 1099, as an independent contractor? And I said, absolutely not. They're like, well, but she's agreeing to it. She wants to be hired as a 1099. Like, this is better for her from a tax perspective. And I said, absolutely not. You have to hire them as a W-2 employee. Now, are there things, if they insist on it, are there things that an attorney can help you do to minimize your liability? Yes. Are you miscategorizing them? Absolutely, 100%. Can you have that conversation with your attorney? Sure. And they will tell you, this is not correct. I can help you so that if they file a lawsuit, your damages will be minimal. Are you going to lose? 100%. Yes. So, you know, these are things where, and the reason I'm bringing this up, and the reason why these are such great conversations is, you don't have to know everything, but you do need to be able to recognize that you might have a problem and call an attorney, right? If you even think that something doesn't pass the sniff test, call me. I will answer your questions for free, and I will tell you, you should go talk to an attorney, even if it's not me. But you do need to know enough to know that you need help, right? And even if you think that you're not quite sure, call an attorney. And I know that sounds self-serving, but I promise you, it's not. The heartache that you will be saving yourself in the future is so much, because lawsuits are terrible. I'm an attorney. I've been doing this for 22 years. I hate litigation. I don't want to be in litigation. It sucks for me, and this is what I do for a living. I cannot tell you how much of a pain it is for my clients to be in litigation. I want you guys to not have to deal with that. It's terrible. So I just want you to know enough to know to call an attorney. We actually have, the one other thing that we had talked about, somebody had sent in a question about leave. Again, you need to know enough to call an attorney. California there's a federal law called, it's Family Medical Leave Act, FMLA. It applies to employers who have 50 or more employees. California has a corresponding act called it's CFRA. It's California Family Rights Act. Yes, thank you. And it used to also apply to 50 or more, but it's now 5 or more. So if you have 5 employees, you have to provide CFRA leave. It provides 12 weeks of protected, unpaid leave for certain conditions like pregnancy, medical, new child, to care for a family member. You don't have to you don't have to pay anybody. You don't even have to pay benefits during this time, but you have to provide benefits at the same, you have to allow them to pay for their benefits and maintain their benefits. But somebody asked, like, how do we offer this leave without other people, like, questioning it or setting a precedent? And it kind of goes back to, like, my first opening statement, which is compliance, clarity, and consistency. CFRA leave applies to almost all of you. You have to provide CFRA leave. If it's in your handbook, the criteria is there. All of the employees can look at it and know that that's how you get that leave. That's how, if you have a condition, you come to your employer, you talk to them about it, and you say, I have this medical condition. What's the documentation I need? When do you need it by? What do I get? Compliance, clarity, consistency. it's in the handbook, or it's on the website, or it's available to them, then it doesn't look like you're playing favorites. Then you just know.
Any part-time employees or full-time business?
CFRA applies to all employees if they meet the specific criteria, which I believe is they have to have been employed for a full year and have to have worked for, I think it's 1,200 hours in the year. Sorry?
About 1250.
Yes. Yes. 1250. So if they meet that criteria, doesn't matter if they're part-time, doesn't matter if they're full-time, it applies. They get it. I'm actually going to leave it there because I know we've got a limited amount of time. Does anybody have any specific questions?
If you have just like an assistant that works 10 hours, but kind of hits that ABC, is it still, are they still an employee?
Yes.
Okay, so it doesn't matter how many hours
Nope.
they would be an employee, a W-2?
Yes.
Okay.
Again, if that person chose to, what I would do is I would, if treating them as a W-2 is going to like break your business, there are things that you could do to minimize your damages, like keep track of their hours, make sure they're getting meal and rest breaks, treat them as a W-2. Is it still wrong? Yeah, they are misclassified. But can you minimize the liability? Sure. And we can talk, but yes, they would still be a W-2. Doesn't matter how much time.
I work with all levels of business, whether it's mom and pops or multinational corporations, and many of them, most of them, hate doing work in California. Get out if they could, other than the talent and the sunshine and facts here.
Yep.
I'm curious from your perspective, what's the one thing that Sacramento could do differently that would make it easier or better here?
Honestly, the main thing that plagues a lot of my clients right now is AB5, is the independent contractor W-2 thing. It really, because, and I get why they did it, and I get protecting individuals who don't have leverage a lot of times in those negotiations, and so a lot of times, they're like, I guess if you want to treat me as an independent contractor, I'll do it, right? I understand that, but for a lot of my husband is a screenwriter, so I get that a lot of people actually do want to be treated as an independent contractor. In 2021 and 2022, there were a lot of industries that lobbied really hard in Sacramento to get carve-outs from AB5. And so there are attorney carve-outs, there are accountant carve-outs, there are graphic designer carve-outs and writer carve-outs. But it's really difficult, and it's really affected a lot of industries, particularly the entertainment industry and like the retail industry, for people who make their money being independent contractors, and now people can't afford to bring them on because payroll is a big cost. Like shifting somebody from an independent contractor to an employee adds about 20% to your payroll, so it's very expensive. So I would say that that's like the number one thing that I would love to do is create a broader carve out for people to opt to be independent contractors. But that's like the major thing.
I just want to take a minute to say thank you to you and all the HR lawyers out there. I know as a small business, I'm not technically the owner, I'm the manager of the business. As a senior pastor, I have 17 staff under me. It's an enormously difficult thing. Now I have the ministry side, which is more complicated with tax law and all that stuff too. I would just say this: use the HR lawyers for as much as you can. don't try to do it yourself.
Yes.
It's just your own mental health alone is worth the money up front. Get your HR things in order. Send them your employee handbook. Send them every time you're going to terminate an employee, every situation you have, email them and ask them questions. Whatever money they charge you, you're going to make it back and not having to go to trial or not having any litigations and things like that. But most of all, for your own mental health, you build a team around you of experts to help you get yourself situated. Because once you get it installed and you're in the flow, it's magical. It's wonderful to feel confident. And then if you do get an employee who wants to bully you or manipulate you or try and use the laws against you and look for non-compliance, knowing that you're in order and knowing you've got somebody like her in your corner, it's so much easier and more relaxed in how you deal with your employees. And then it's less personal. It's easier to let people go if you have to. You're not signaling people out. I just say, for your own health, just use her and use these lawyers as much as you can because it's really worth it.
And I do, thank you so much. And I do want to say, like, you can get my information from Lori or from Jesse or from Carrie. I am always happy to just answer questions. I will never charge you unless I have to. I don't like to. I'm that kind of a person, honestly. Unless I have to write a letter on your behalf or appear in court on your behalf, I will try to do as much as possible to walk you through a situation because I don't like people getting sued. It's stressful for me to think about people getting sued. My husband was on jury duty a week ago. He came home and he said his Apple Watch alerted him 3 times in a day, and it's never done that before because he was so stressed out being on a jury. Juries are terrible. I don't want any of you to be in litigation. So please, please, please reach out and ask me.
I'll support that. I was chief financial officer for a firm with 1,000 brokers, and I can assure you, if you go into major litigation, the sapping of energy and ability of your senior management to focus on the business. The business is hurt because they're focusing on something else rather than managing the business. So if you can avoid...
It's so much nonsense.
Avoid litigation.
Yep.
Sometimes you don't want to settle. You're going to save money by settling sometimes. But from the distraction of management from your company.
Absolutely. 100%. 100%.
Well, again, thank you so much for being here.
Of course.
Thank you. I just want to give a really quick plug. If you need something as basic as your employee rights notices poster that you put in your break rooms, the chamber has them, or we can order them for you. We also have some of the basic pamphlets and stuff you need. So reach out and we can certainly get you all that information. We really appreciate you being here. We will definitely keep your contact information.
Absolutely.
A couple things coming up, as we've heard. On Saturday is the Arts Crawl, so from 2 to 7, be sure and go to stores and shops and South Pass Arts and Music and play the musical Petting Zoo, and Dave with all his music and activities in his store. And there's over 25 merchants and restaurants that are doing special events, so come on out and enjoy South Pass on Saturday. And we will see you. Our plan is to move from the daily back to Mike and Ann's in March, but we will confirm all that and get back to you. But next March 3rd, 8 o'clock, we'll see you for Shop Talk. Thank you all for being here.